Lynn Huerta versus April Despain, 230904766. Looks like we've got petitioner present along with her counsel, Kennedy Nate and Austin Nate, and we've got respondent present along with her attorney, Mr. Maraboni. We're here for closing arguments. Thank you for your briefing. Really very helpful. I read it all. I think I've read all the cases. I'm very familiar with the facts, obviously. So I'm ready. I'll turn it over to who's going to take the lead.
I will, Your Honor.
Okay.
Good morning, Your Honor. And obviously, if the court has specific questions that it would like me to address first, I'm happy to do so. Otherwise, I have prepared some comments.
I guess I do have two sort of. Oh, we're on. Okay. I do have two sort of preliminary questions. One, I wanted to make sure. It looked to me like the statute that you cited was the old version of the stalking statute. It is my understanding that the current version would apply. Do you disagree?
No, we believe that the current version applies. Okay. But for our purposes, it's irrelevant because we're arguing the no standard.
Okay. Okay. And then the second question is, a lot of the briefing, I mean, you cite the standard a reasonable person would fear for their safety, et cetera. Although the definition of a reasonable person includes a reasonable person in the petitioner's circumstances. And I didn't see a lot of discussion about that. So that would be helpful.
Absolutely, Your Honor. And here I would say in the petitioner's circumstances, obviously we're talking about a private individual. Ms. Huerta is a private individual that engaged, and there's been no attempt to hide this, online with respondent for 5 days. Mm-hmm. And she sent the flags. There's no dispute that occurred. However, after things began to escalate, starting on May 28th, she cut off all contact with respondent. She was then contacted by the police, told to knock it off, which she had already done, and she believed that would be the end of it. And so that's really where we think when we're talking about the petitioner's circumstances in this case, although she did engage when the police intervened and told both sides to knock it off, that essentially put petitioner in a position where she believed she would be left alone. Obviously that did not happen.
I see. So from your perspective, everything starts on May 28th?
Yes. I mean, obviously there is a course of conduct that begins because the parties are engaging, starting in early May. However, it becomes entirely one-sided as of May 28th. So as of May 28th is when Ms. Huerta blocked respondent. She did not engage with her anymore. There was no more online posting. And we see the very next day on May 29th in the exhibits that respondent posts about it. Hey, she's blocked me. I can't communicate with her anymore, which reaffirms that petitioner was trying to disengage. It was that next day, the 29th and the 30th, that the police visited both individuals and told them, hey, you got to stop. Obviously, at this time, petitioner, Ms. Huerta, had already stopped. She had disengaged. She expected this to be done, but it didn't stop. It continued on and has continued on to this day.
When you say that it's continued on to this day, there was like allusion to that in the briefing. I don't recall any real testimony about that. So I guess what does that mean? So
at trial, Ms. Huerta testified that the posts were continuing up until the date of trial. And Your Honor, obviously one of the things that was submitted here was a supplemental declaration after trial, which we think is improper because the parties already had the opportunity to argue. However, if the court is inclined to consider it, we do have dozens more of posts that reference either Ms. Huerta by name or by the moniker PTA president. We have not submitted those because this case has already been going for over 2 years. Mm-hmm. However, if the court is interested in considering those, or if that is part of it, if the court's willing to consider the declaration that we submit was untimely filed, we have those available and we can submit them. However, we haven't done so because it's essentially more of the same. So really, the key pieces of evidence that the court would want to look at.
And those are posts on a social media platform?
Correct. That's correct. On Facebook, Twitter, and Instagram.
By Ms.
By Ms. Despain, that's correct.
Okay.
In fact, if memory serves, I think as of yesterday even, there was another post referencing posts from other locations that specifically contained Ms. Huerta's name. But for purposes of the stalking injunction, it's essentially more of the same, Your Honor. And because only 2 instances are required, and we would submit that the evidence that is already there is more than sufficient to establish the 2 instances, it's cumulative at this point, although it does go to the Ragsdale issue of whether, or I guess the cumulative effect on the petitioner. And so that, I would say, is the other key point.
How are these being viewed, these current posts? I mean, it's my understanding, I think you said that she's blocked her, she's gone private on social media, so how is she even aware of these, or anyone aware of these? Are you monitoring? Is that the...
So I am not, Your Honor, but I do know that third parties have sent them to Ms. Aorta, and that's generally how she's made available, or made aware of them. And it really comes it's very similar to the Harris v. Hunt case that we cite in the papers. In that case, if the court recalls, the respondent said, hey, well, I'm just posting on my private social media page and I'm not intending it to get there, but the petitioner found out about it because third parties were submitting this, saying, hey, he's talking about you, he's saying these types of things. It's essentially the same course of conduct that we're seeing in this case. And so when we look at, the petitioner and the petitioner's, specific circumstances here, we look at, yes, there was some prior engagement. That's true. However, that engagement was broken off, and then for the last approximately 2 years, it has been a one-sided engagement with posting online, mocking online, harassing online, all directed to Ms. Aorta, either by referencing her name or continuing the PTA president moniker that was created. Ms. Despain admitted that she wanted people to associate that name with Ms. Aorta, and she's continued to use it, and she has continued to post images as well that feature Ms. Aorta's name. And so when we look at this, the petitioner, in her particular circumstances, it's someone who's no longer engaged, no longer responding, and there's a cumulative effect of what's going on. And the reason why that matters, Your Honor, is because it is basically respondent delivering on the promise she made to Ms. Solis, which was that she is going to make an example of Ms. Aorta and continue to mock her for the rest of her life. And so far, she's followed through.
Okay. All right, that's helpful. I don't have any other questions out of the box, but I'll ask as we go along.
Perfect, Your Honor. And I think really we've already started down this path, but as the court said on the last day of the hearing, the only question here is whether or not there was stalking. That is why we are here. Despite that being the only question, in the 170 pages of briefing that was submitted by a respondent, it largely focuses on things that are not her conduct. It focuses on alleged failure to include all information at the petitioner's conduct, and various other things. But when we focus specifically on the elements of the stalking injunction statute, the case law, we just mentioned Ragsdale, the Harris case, I guess both Ragsdale cases, it is very clear that Ms. Aorta has established by our preponderance of the evidence that she has been stalked by respondent. The first element is satisfied, Your Honor, we would submit in spades. There was a clear course of conduct targeted at Ms. Aorta. This course of conduct is listed in the various exhibits. Respondent engaged Ms. Aorta both directly and indirectly. Early on, they engaged directly, and then after she was blocked, she still attempted to engage her, including by posting about her, informing individuals that she knew were affiliated with Ms. Aorta, like Gabriel Smith and Brittany Dunn, saying, hey, since she blocked us, I hope these 2 people can let you know that I'm still talking about you. She asked others to post about her. Nicole Solis, we've seen that exhibit. She asked others, she admitted to monitoring Ms. Aorta at least 2 times by going to her social media. We heard Mr. Despain testify that he went to Ms. Aorta's social media accounts, pulled images at his wife's request. She posted Ms. Aorta's name, her picture, created the moniker or the nickname that we've heard about, the PTA president, and then continued to use that name and posting about her dozens of times, if not hundreds of times, since this began back in May of 2023. Now, in papers, respondent has argued that there was no course of conduct and she didn't actually target her. That's simply not a credible argument here. In fact, in light of the fact that she listed her name specifically, included images of her, and then continued to use the nickname that she created for her. And in fact, I think both the Ragsdale one and the Harris cases are indicative of that. Whether or not she intended the messages or the statements that she was making to actually make it to Ms. Owerta, respondent was talking about her. She was communicating to or about her, which falls squarely within the language of the stalking injunction statute. She was monitoring her by looking at her social media and then having other people do the same. So as it comes at bottom, Your Honor, we've established by a preponderance of the evidence that there was a course of conduct that was targeted at Ms. Owerta. The second element is also satisfied. Ms. Owerta has testified that she feared for her safety. I know that we're dealing with a reasonable person standard, but here, under the circumstances, a reasonable person in petitioner circumstances would have feared for her safety, and we've talked a little bit about this already. But it stems from the fact that as of May 28th, there was no more engagement. You've seen in the papers that respondent argues and says, hey, well, I was just defending myself and I was just explaining, what was going on here. That's all fine and well until May 28th when Ms. Owerta had totally disengaged. At that point, it's no longer defense, it's attacking. And maybe the belief is a good defense is a good offense, but ultimately what happened is post May 28th, all of the communication that was directed towards or at Ms. Owerta was one-sided. There was simply no one left to fight against or defend against unless or until Ms. Owerta ultimately filed the civil stalking injunction trying to get the conduct to stop. But rather than stopping, she has continued to attack her. She's made fun of her. She's asked other people to post about her. Respondent didn't stop after being told to do so by the police. Respondent didn't stop after being served with the stalking injunction order, and she hasn't stopped to this day. And when
the fearing for her safety, that's related to the death threats, right?
Combination, yes. So yes, it does relate to the death threats in part, but also just the cumulative effect of having respondent continue to post about her, to continue to post mistruths about her, and to continue to represent that Ms. Owerta is some sort of surrogate for Murray School District is very, very concerning because there's no truth to it. It impacts Ms. Owerta. It impacts her reputation within the community.
Well, setting aside the death threats, tell me why there would be fear for her safety.
Because of the ongoing posts. Because the cumulative effect of the posts. This is where I would say the Ragsdale case and the Harris case, and Ragsdale 1, are very on point. Because in Ragsdale 1, the Supreme Court explained you have to look at the cumulative effect. And it wasn't necessarily, although there was content in Ragsdale 1, I know the court knows this better than most.
Yes, very familiar.
Yes, that there was conduct that was concerning and that was scary. But one of the...
That was in person.
It was in person.
Very different than this. Very different.
I would say it's not that much different in that because there's images being posted of Ms. Owerta, her name is being posted, her location is being posted, and then all the other stuff that started to happen.
Who's posting about her location?
So referencing that she's in Murray School District along with her name, that makes it very easy to locate who she is and where she's at. They never posted her address, Your Honor, to be clear. We're not arguing that occurred. But the fact of the matter is, by identifying who she is, where she lives, and the school district that she's affiliated with, that makes it very easy to locate her. So yes, I will, while it's not the same as being next door to someone and having them yell at you when you pull up, it's only a slight step down based on the quantity of the posts. Because it continued on, it still continues to this day. There's been dozens of them, if not hundreds, as Ms. Owerta testified.
But if there hadn't been the death threats, there'd still be fear for safety because... Absolutely, Your Honor. Because of the ongoing comments about her and the misrepresentations about what Ms. Owerta purportedly did and what she's doing. It tends to show, Your Honor, that there is either an infatuation or a potential obsession with Ms. Owerta and that it's something that can't be let go. And when someone continues to post about you, talk about you, even though you've not engaged with them for over 2 years, that would definitely cause a reasonable person to fear for their safety. And I would highlight the Harris case, for example, Your Honor. That case involved interactions that were all online as well. Posting about the individual, things that he allegedly had done, misrepresenting positions that the person had taken. And the court found, and it was sustained by the Utah Court of Appeals, that that was sufficient to
establish the second element of stalking. And so from our perspective, even setting aside the death threats, there's enough here for a reasonable person to be concerned, to fear for their safety, just because of the cumulative effect of the ongoing posts. And then lastly, Your Honor, because of that, it's not just something that's happening in the Ethereum. Respondent made clear what her goal was. Her goal was to publicly mock Ms. Alwerda for the rest of her life and to make an example of her. That's precisely what she said to Ms. Solis. She said that in text messages that she thought would not be discovered. And she thought that they were private until discovery in UPEPA was permitted. And under UPEPA was permitted. And so for that reason, she indicated what her true goal was. Her true goal was to continue to harass her, and she's made good on that promise, as I mentioned before. And this is particularly so after Ms. Alwerda informed her, hey, I've started to receive death threats. The demand letter was sent, back in June. Respondent received it, never responded to it, never did any investigation to it. The only thing she did was post online saying, anybody can claim to have death threats, but I don't think it actually happened. There was no attempt to try and verify whether that happened. As we submitted to the court, there were death threats that were submitted, Your Honor. They were all, not all, but virtually all of them were in connection with the Daily Caller article, post on Instagram. But why does that matter? Because even if Ms. Despain herself did not post those, she was driving her followers there. She included the hyperlink to the Daily Caller
There's
Instagram.
no evidence that those threats were posted by her followers.
That's correct. No, that is correct.
So, couldn't those posts have been there? The threats were, the origin of those threats was the article.
Correct. The article, which was based on the statements that Ms. Despain made about Ms. Alwerda in the article.
Well, it was based on flags.
Well, it was, but it also, if we look specifically at the article.
So you think if there weren't any statements by Ms. Despain in the article, it was just about the flags? No death threats.
I think that if Ms. Despain had not done the interview, there would have been no article and there would have been no death threats.
Is she not allowed to do that interview? A stalking injunction, a stalking statute prohibits that?
No, I believe that she can do interviews, but she has to be careful because, as the stalking injunction statute says, you can attack indirectly through third parties. And what we've seen here is it wasn't just the Daily Caller article by itself. It was the read line, the other interviews and things that she did.
All of that was pre-stalking injunction, right?
The read line, I believe, was post-stalking injunction.
Okay.
Article, yes. And I can tell you exactly which exhibit that is, Your Honor, if you're interested.
I'm sure I know where it is somewhere.
Sorry, there's been a lot of them.
Yeah. But regardless, the death threats were on the Daily Caller's Instagram.
That's correct.
And that article ran about a month before the respondent was served with the stalking injunction.
That is correct. That's correct.
And so, what part of that is attributed to the respondent's course of conduct for purposes of stalking?
Absolutely, because the statute says if the respondent causes, and here there's been a lot of argument over what is causes, and essentially the respondent's taken the position causes is limited to if I tell somebody to do so or I instruct them to do so, that's causes. We would submit that that is not what causes stands for. In fact, when you look at the definition in Blacks, as well as, for example, the definition in Merriam-Webster, it explains, and let me get to that here real quick, Your Honor, I'll tell you exactly what it says, that cause is defined as to serve as a cause or occasion of. So a cause, we're not talking about the only cause. Here, as we argued in our response, the fact that respondent was continuing to post about her, had included the Daily Caller article there with the link and was driving people there, that created the circumstances where the posts were made.
Isn't Petitioner at least equally responsible for that? She sent the flags. There would have been no article but for that, right?
That is correct, but I will say, so she's not, I would say Ms. Alwerda could be considered one of the causes, but I would also say that respondent is the proximate cause because she's the one who gave the interview, posted about it, and included the hyperlinks.
Even though none of her followers were even the ones who made the death threats. So whether she posted about it, how does that connect to the death threats?
How does it connect to the death threats?
Yeah.
It's the fact that it doesn't have to be her followers that are the ones that post about the death threats. All that's required is that she causes the conduct indirectly or directly. And here we would submit that it is indirectly because of her leaving the post on her Facebook or on her social media, and particularly on her Instagram page, after she was informed about the death threats. She's never taken it down. It's still up there. You can still find them. You can still access them and get to it. And so because of that ongoing conduct, we would submit, Your Honor, that's sufficient to establish at least one of the incidences of stalking that would cause it. But at the end of the day, it's not just the one instance, right? Looking at the death threats by themselves may not have caused a person to fear because nobody knows who these people were that were commenting. But it's in the context of the ongoing posts, continuing to post about Ms. Alwerda, continuing to try and drive interest, arguing that Ms. Alwerda is trying to stop petitioners' free speech about LGBTQ issues at Murray School District, which is simply not the case and never has been the case. All of that combined establishes that a reasonable person would be concerned because respondent was feeding into this false narrative that petitioner was trying to shut down anybody from having a different voice because she supported LGBTQ issues. That's where it fits in. So by itself, perhaps it may not be enough, but in the cumulative effect of it, Your Honor, it establishes that respondent was engaged in a course of conduct because her end goal was, as we say, was to try and establish that she is a religious martyr who has been targeted because of her religious beliefs, even though there's no evidence to support that that's the case. Now, we've talked obviously about the death threats, Your Honor, but keep in mind, at the same time that all this is occurring, Ms. Alwerda also received direct messages from people that were threatening to her. She'd not received those types of messages before, and Ms. Alwerda, I think, had testified that she was previously involved in other LGBTQ issues. I think there was testimony that came out even that she had been involved or on the news before. Despite that, she had never experienced this type of vitriol or received these types of messages. On top of that...
But how much of that do you think is about this flag issue? I mean, I understand you acknowledge that it happened, but it seems like you really minimize. I mean, I would be very upset if someone ordered anything, really, to be delivered and propped up on my personal private property without my knowledge or permission. I would find that someone that didn't know me located my address. That would be very scary to me. And so, I mean, we have to account for that. I mean, this, like, a lot of, I think she even acknowledged in the stand, she wouldn't be here but for that, having done that. And so how does the court, I mean, that precipitated a lot of this. I mean, she also, she didn't get direct messages with threats because she hadn't done that either. I mean, we're setting aside what Ms. Dessine posted about.
So, and let me address that, Your Honor, because I think that's a great question. I do think that in the short term, some of the stuff that occurred could potentially be attributed to just the sending of the flags by itself. However, the problem we have is with timing. Because as we see, things, the farther away you get from an incident, the less relevant they become. The only distinction to that is when someone continues to bring it to the front of everybody's newsfeed or social media posts. And that's precisely what respondent has done here. Instead of moving on, letting it go, she believes she was wronged with the sending of the flags, and even Ms. Alwerda recognized she wished she'd never done it. She realizes it was a mistake given how it's all played out. But at some point in time, you can no longer rely on, hey, they did this to me 2 years ago, and so I still get to post about them, harass them, attack them, and do all these things. I mean, to put it similar to what we argued in our brief, someone could use the exact same thing, like former boyfriends and girlfriends. The boyfriend could say, well, we dated 2 years ago, and the fact that she engaged with me and broke up with me or broke my heart 2 years ago means I can continue to come after her. The problem is that doesn't justify it forever. And clearly it doesn't justify it in this case, including because Ms. Alwerda attempted to completely disengage. She stopped engaging with her. She didn't post anymore. She did not send anything further to her home, and other than the litigation, there's been no further connection between these two. And the litigation is centered on Ms. Huerta trying to stop respondent from posting about her. And so that, we would submit, Your Honor, is one of the key distinctions as to why it makes a difference. If this had all happened just within the span of a month, we may not have been here. It's the fact that it has continued to be ongoing, and that it is ongoing through today, that it is exceptionally problematic, because it enhances the cumulative effect. If somebody, gets mad at you...
I mean, in the evidentiary hearing, what was the most recent posting that was presented?
I believe the most recent posting was it was either July or August of 2023, that was of the specific posts that were included, but there was testimony. Ms. Huerta testified that she was continuing to post about her up until January of 2025. We don't have specific, we didn't submit those into evidence at this time, but the testimony itself, it constitutes evidence that the court can consider. But so I believe the last one was in July, and it related to...
That's my memory, related to the GoFundMe or something like that.
Yeah, I think the GoFundMe was the last one that was submitted. And then, of course, the posts about on Twitter, so Exhibit 71 and 70, or pardon me, 70 and 71, that talked about the death threats, which were June and July. But, Your Honor, and so that's one prong that we can look at is the fear, right? The other one is the emotional distress. And here I think we have an even stronger argument. I think the argument for, someone, a reasonable person would fear, given how much conduct has occurred, I do think it's even stronger under the emotional distress. Here you heard testimony from 3 individuals, Mr. and Ms. Huerta, as well as respondent herself, that they suffered emotional distress as a result of this engagement. The difference is that the engagement that involved Ms. Huerta was only 5 days, and respondent has continued to engage now for nearly 2 years. But the exact same factors, the exact same conduct that go to the fear issue also go to the emotional distress. Whether or not respondent specifically caused all of the events, or she instructed somebody to post, is irrelevant. She's the one who poured out the gasoline, lit the match, and then stood back and said, hey, I'm not responsible for the explosion. Because she continued to post, and as I said, she continued to misrepresent the nature of the dispute, Ms. Huerta's claims, and her actions. Under these circumstances, a reasonable person would have suffered emotional distress, including because respondent lied about the nature of the dispute. And this I really want to highlight here. We've talked a little bit about it, but I'll refer the court to Petitioner's Exhibits 27, 29, and 30, which are the initial GoFundMe posting, or pardon me, the GiveSendGo posting, Your Honor. And what is relevant here is what's stated. It says, I'm being sued by Murray School District, Utah PTA president. Ms. Huerta was not the PTA president. In an effort to...
I mean, it's not unreasonable to believe that Ms. Despain may have believed that she was.
It's not unreasonable, except for when we went to trial, and she testified at trial, well, she's still the PTA president. I confirmed it, despite the fact that...
Right, but
you're talking about this post.
At that time.
At this time, based on the post by Murray School PTA, that Ms. Huerta had been nominated, and we don't necessarily challenge that portion. The more concerning portion comes later. It says, in an effort to silence my free speech about teachers promoting LGBTQ flags and curriculum in Murray's public schools. That's not what this case is about. That's not what was sought in the stalking injunction, but it was a blatant misrepresentation that respondent made so that she could drum up money. And in fact, in her testimony, she said, well, it's not as impactful if I can't talk about it, but if I say I'm some little mom who's being attacked based on my religious beliefs, people are like, yeah, I want to donate. And so she was motivated to intentionally misrepresent the nature of this case to drum up money and to create interest, despite the fact that that's not what this case has ever been about, nor is it what it's about as we sit here today. So that is, one of the things that would cause a person to be or to suffer emotional distress. Once again, we're not talking about just a single instance, but it's the ongoing posting, the ongoing attacks, the mocking Ms. Huerta because she claims she never suffered any death threats, even though respondent herself was receiving death threats at this time. All of this, Your Honor, is enough to make a reasonable person suffer emotional distress. And particularly, we would say, in the Harris case, which was, once again, entirely online engagement. Very, very similar to what we have here, but I think with even less posts targeted at the petitioner in that case. We would say that that case it sets a great example of why the stalking injunction should be kept and stay in place. Then lastly, the important, I guess the last key important point on both emotional distress and as it relates to the fear is the fact that a temporary civil stalking injunction was served. Respondent testified that she received it, she read it, she understood it, but she didn't stop posting about it. She continued to post, as we just saw one of the examples there, that she continued to post about her and said, hey, I need money because there's this lawsuit about someone trying to silence my free speech about what's happening at Murray School District. We would submit that was in violation of the stalking injunction order not to directly or indirectly harass or annoy Ms. Awerda. And it didn't stop there. She continued to post about her. She gave interviews to the media, as we talked about, post-service of the stalking injunction statute, and ultimately created a false narrative that it was Ms. Awerda who was acting on behalf of the school district as some sort of a surrogate to try and target respondent, which is simply not true. At bottom, Your Honor, as the court is aware, that it need only find 2 instances of stalking that are required. There are dozens in evidence. They include monitoring directly and indirectly, communicating directly and indirectly. They include talking about, communicating to or about Ms. Awerda in spades. And so we would submit, Your Honor, that just as in Ragsdale and in Harris, a reasonable person would suffer emotional distress or have feared for their safety based on the respondent's ongoing conduct. Now, some of this, Your Honor, there has been quite a bit of argument about the credibility of the witnesses here, which, no surprise, that's what people do after trial. A respondent has argued in her papers that she is the only credible witness in this case, and we would submit that that simply doesn't hold water. We identified some of the bases for that, but I do want to highlight a few here today. In particular, page 22 of respondent's closing argument and page 50 of her response, respondent argued that she, quote, stopped using petitioner's name in social media posts and would refer to petitioner as PTA president, end quote, after May 30th. That's not accurate. In fact, if you go to exhibits 25 and 26, respondent posted using petitioner's name on 2 separate occasions, one which appeared to be on Facebook and one which appeared to be on Twitter. So exhibit 26, which is actually the earlier in time, was posted on Twitter at 4:15 p.m. on June 23rd, 2023, obviously well after May 30th. And she says, after Murray School District PTA President Jen Awerda harassed my family online and sent 7 pride flags to our house because we don't believe in gender theory, she threatened to sue me. And then she included a copy of the demand letter. She did virtually the same post that I just read in exhibit 25. So her statement that after May 30th she didn't refer to her by name is objectively wrong. Next, we already talked about this, and so I will hit it very quickly. The exhibit 27, 29, and 30, where Ms. Despain intentionally misrepresented the nature of the case and then, of course, asked Ms. Solis to support her. Ms. Solis did. She posted the same thing, misrepresenting what the nature of this case was, all in an effort to try and raise money. Third, once again, we've talked about it, but very, very quickly, despite the fact that there was no evidence submitted at either day of the evidentiary hearing that Ms. Awerda ultimately became the PTA president, respondent continued to testify and say she was the PTA president, refusing to acknowledge that Ms. Awerda never became the PTA president. And then lastly, Your Honor, and the biggest one for me, I think, which stands out, was when Ms. Despain was confronted with the fact that this case has been delayed by 2 years based on the motions that have been filed by respondent and their litigation strategy. Rather than acknowledge her actions, she blamed her prior attorney, testifying that she did not choose the strategy and that her counsel ignored her and did whatever he wanted. That's simply not credible testimony, Your Honor, in light of what we know about this case and what was submitted. And tellingly, we know that that's not accurate because respondents submitted declarations in support of each of the motions that were filed that she purportedly claims were done without her knowledge or her consent. She showed up to the UPEPA hearing, indicating that she knew it was ongoing. She sat in this courtroom, and apparently she did both while being ignored by her counsel and him doing whatever he wanted, purportedly. And I want to be clear on this, Your Honor. Mr. McCullough and I did not see eye to eye on this case. No surprise there, as we were opposing counsel. But to accept respondent's testimony, the court would have to believe that he prepared those declarations and signed them without her authorization, which I simply do not believe to be the case. And in fact, we know it's not the case because Ms. Awarda Ms. Despain told Nicole Solis precisely what she and her attorneys were doing. In the text messages, specifically at Petitioner's Exhibit 64, page AWD 000232, it's a text message that begins on July 12th, which is an important day because July 12th is the day the first motion to dismiss was filed. She says to Ms. Solis, "So I switched attorneys because I got this one who specializes in First Amendment suits. I'm super excited about it. We put our crowdfunding back up, so feel free to promote. We're going to strike down her injunction as unconstitutional and file an anti-SLAPP in the same motion. He's working on it now." We then saw later in August, and we pointed this out in our papers, that respondent provided an update to Ms. Solis saying, "Hey, this is what we've done. We filed the motion, everything's happened, we filed this motion first." So for respondent to testify while under oath that her attorney didn't include her is simply, it's not credible, and it establishes that when confronted with the hard truths, respondent resorts to misrepresenting what happened rather than confronting what actually occurred. It's further telling that in respondent's papers, despite this being pointed out in both our opening brief and in our response brief, there was no argument or acknowledgement of this inconsistency. It was simply ignored. It wasn't responded to, nor has the respondent asked the court at any time to disregard the declarations that were submitted or try and withdraw them because she purportedly did not submit them. Simply when it comes down to it, respondent was dishonest in her testimony, and that raises serious concerns about her credibility based on what she submitted and the fact that most of her defense relies on her testimony. In contrast, Your Honor, Ms. Awarda has been forthright in her testimony, and we've talked a little bit about some of those hard facts here this morning. She admitted that she is the one who initially reached out and engaged with respondent. She admitted that she did so to try and defend teachers that she believed couldn't defend themselves. She admitted to sending an email to Ms. Dunn about ordering the pride flags, and she openly admitted to sending the flags to respondent. And here I do want to pause just for a moment, Your Honor, because in the papers, respondent advances a few arguments that I think need to be quickly addressed. First, respondent argues that Ms. Awarda is not credible and likely would not have admitted to ordering the pride flags if they had not obtained that email from a grammar request. And that's at pages 39 of the opening closing argument for respondent and page 8 of their response. And Your Honor, this argument is simply, it's a non-starter. And the reason why is because Ms. Awarda gave her name to Project Rainbow and her information when she ordered the flags. She wasn't trying to hide who was ordering the flags. After respondent confronted the individuals who were there to place the flags, they told her, this is the person that ordered them. They said it was Ms. Awarda, and I think there's been no dispute since that point. And after respondent posted online about the flags having been delivered, Ms. Awarda subsequently posted online and acknowledged, yeah, that was me. It's not surprising, though, that they would advance this argument because it's an attempt to accuse Ms. Awarda of being dishonest and not forthright when all she's done is admitted the things that she did. Obviously, she admits she wished she hadn't done that, but regardless, when confronted with those tough facts, she was absolutely honest. Second, the second issue that I really want to address is the argument that somehow Ms. Awarda withheld documents in this case and somehow tried to hide, for example, that email correspondence with Ms. Dunn. As the court is aware, with a standard stalking injunction, there is no discovery. The parties go to trial within 10 days and the case is over. And for that reason, it's an expedited proceeding. The only reason there was any discovery in this case was because of the UPEPA motion that respondent filed, apparently the same one she didn't know about, and the parties ultimately agreed to limited discovery on. But what's important is to understand what the scope of discovery was related to. It was related to what I'll cite to UCA, Utah Code Annotated 78B-25-102, which explains that you can do discovery related to, quote, exercises of the right of freedom of speech or of the press, the right to assemble or petition, or the right of association guaranteed by the Constitution. In other words, what the parties were focusing on with UPEPA is, was this an attempt to silence respondents' free speech? The discovery request that respondents served at that time didn't target that. They asked for any communication that Ms. Huerta had had about respondent at any point in time. For that reason, on December 18th, we served objections, Your Honor, and said, hey, that's outside the scope of discovery. There was no attempt to meet and confer. There was no statement of discovery issues that was ever filed. And until the briefing, we thought it was a dead issue because it was not something that was within the scope of discovery. And yet now respondent has tried to use that conduct to argue that Ms. Huerta was hiding the evidence, was playing games, was being dishonest. That's simply not the case, and for that reason, I wanted to quickly address that. Similarly, and related to that, has been the argument that Ms. Huerta was not candid or forthright in the petition that was filed. It ultimately resulted in the temporary stalking injunction being issued. We point out in our papers, and I think it's clear from the papers that were filed by respondent, that there's no legal authority that required Ms. Huerta to provide the potential responses or defenses to her contention. In fact, she was straightforward and she said the respondent has incited a mob against her, and she included images of the things that under the statute tended to prove that she was being stalked. And to argue that somehow Ms. Huerta or anyone in the adversarial proceedings that happen has the obligation to present the other side's argument at the start of the case is simply unsupportable, because that would destroy the adversarial nature of our judicial system as it stands. No party has to present their opponent's case for them, although it would be nice if I could convince opposing counsel at times to do my work for me. Unfortunately, that's not how it works. Ms. Huerta was honest. She said respondent incited the online mob, as I mentioned. There's nothing untrue about that. And as we've said, stalking can occur through third parties. Ultimately, at the end of the day, that argument we would submit is entirely a red herring and is unsupported, primarily because it's not based in any case law, it's not based in any of the rules of civil procedure, nor is there anything that would have obligated Ms. Huerta to alter or change the things that she did when she submitted that petition. Let's see. I think the last issue, Your Honor, I wanted to hit very quickly, and I won't hit it very long, is the awarding of fees. As we point out in our papers, in the event that the stalking injunction is sustained, which we believe it should be, we believe Ms. Huerta should be awarded her fees. We've outlined the reasons, but I would say that the principal reason here is because of how this case has been so unreasonably delayed. And it is, despite the argument that respondent made in her papers that it's Ms. Huerta's fault, that simply is not the case. If this had followed the typical stalking injunction statute, we would have been in this exact same scenario 2 years ago, instead of doing it as we are now. And that is entirely because of the decision that was made by respondent to file the UPEPA motion. And it seems at the time, respondent didn't understand the implications of it. Ultimately, we had various conversations with the court and agreed that it stayed the case because that's what the language says in the statute, and we had no choice but to deal with it first. But that was not something that Ms. Huerta chose. That was something that respondent chose. And on top of that, we have seen the pattern of filing motions only to then withdraw them and then file new motions that address some of the same conduct, causing significant increase in fees in this case. And you heard Ms. Despain lament on the stand. She's not a rich person. She's gone into debt. But that's entirely a consequence of her own actions, of the decisions that she made in this case. It has nothing to do with Ms. Huerta's strategy. And so for that reason, if the court upholds the stalking injunction, the temporary stalking injunction, as we believe it should. We also request that the court award fees. Your Honor, do you have any other questions for me?
I don't think so. Thank you.
Thank you.
Mr. Maragoni.
Okay, let's scroll up. I guess I can start talking, Your Honor, but if you have questions to start, I'm happy to answer them.
Well, I don't have any threshold questions, so you can just get started.
Okay. I just want to start by saying I think it was helpful here to be able to go through the evidentiary hearing to see, to get a sense of what the actual factual
Yes,
situation was.
evidentiary hearing is generally very helpful.
Yeah, and so, and I think what those facts actually show is that it was not my client who was stalking the petitioner, rather it was the other way around. It was petitioner who has been targeting and monitoring my client since May 16th of 2023. And really, at the time that this happened, my client had no idea who the petitioner was. She didn't know who she was. She had no awareness of her. She never posted about her because, again, she didn't know who she was. And my client only started to comment on posts or to respond after the petitioner went onto her social media sites, which happens 7 days after the petitioner ordered those pride flags, and also emailed Ms. Dunn about them. That's when my client starts responding. And she's doing it to defend herself because petitioner goes onto her social media sites and makes all sorts of very personal comments. You know, the first comment is about how she's not a good member of the LDS faith, which I understand is, I think, a very sensitive topic for people. It's about how she's a sore loser because she lost a school board race. And then the second comment exposes a private family matter to the public that people wouldn't have known about because it was actually in family court. So, and I think one thing, just kind of an overall point, is that petitioner had, she had motive to go after my client and to silence her. And you can kind of see that a couple ways. One is if you look at the witnesses that she listed in her, her request for a civil stalking injunction, they're all people related to the Murray School District. So, for example, and the information about each of them is actually in the text messages between my client and Ms. Solas. So, for example, let's see here. It's like, okay, so Linda Awarda is one of the witnesses. That's actually the petitioner's mother-in-law. She's a teacher. Mindy Millerberg Ball is a principal who had an affair with another principal, and that was exposed by my client. So there would be obviously like a vendetta, maybe. Juliette Reynolds.
These are people who witnessed the stalking, so they were listed in the petition? Is that what you're talking
These
about?
are people listed in the petition
Okay.
as witnesses for the stalking.
Got it.
But the reality here is that all of the stalking or all of the incidents that they're claiming make the course of conduct are social media posts, so anyone could be a witness for them that's seen that. It's not, so there's no indication here there's something further besides they saw the posts on social media. Also, Juliette Reynolds and CJ Wilkinson were leaders of the Murray Equity Alliance, which was formed after my client exposed the Murray Equity Council and it was disbanded. So, now the other way you can see that is that after she gets the stalking injunction, petitioner shows up to a Utah State Board of Education meeting. And
This is like a long time later, right?
yes, Your Honor, yeah.
Okay.
Yeah, and I'm just trying to get kind of an idea of like the motivation here.
I see.
She shows up to this meeting, and as my client testified, she had been going to these USBE meetings for a couple of years and making regular comments as to various issues that related to things like pride flags or ideologies being pushed in the schools. Never seen petitioner ever. Then she goes to this meeting after petitioner gets stalking injunction. She sees petitioner there, and petitioner is trying to get her to be excluded from the meeting. And so you can kind of see that there's a definite effort here, I think, to silence my client. And as my client testified, the only reason that she was talking about petitioner is because she targeted my client and her family. She said, I'm not just talking about Jenna Werda. I don't care about Jenna Werda. Like I said, I didn't know who she was until she came onto my Facebook post and started harassing me and my family. And like I said, my client never interacted with the petitioner until, again, petitioner went onto my client's social media sites and started interacting.
And that's true, but at some point, isn't there like an end to that? Like, doesn't it have to stop?
Well, to that point, Your Honor, I think actually I went back through because remember, we made a distinction between posts and comments, right? And so with the comments, there will be a tag when you respond on Facebook. It's just what Facebook does. But if you actually go back and look at all of the posts that my client did, she never tagged the petitioner in those posts. After May 30th, she actually blocked the petitioner on all of her social media. And so if you look at this from the objective viewpoint, you can see that my client was never actually directing her communications toward the petitioner. She was, again, trying to tell her story about how the actions of the petitioner were impacting her and her family.
Right, but the stalking statute prohibits even, communicating about someone, potentially. I mean, that would be a violation of the stalking injunction. And can be part of the course of conduct.
Actually, I would disagree with that, Your Honor, because
Okay.
I think if you look at Ragsdale versus Fischler, the second one, as well as which positively cites the Towner decision. Towner actually makes that distinction between you posting or directing your communications to someone versus posting about them.
Although that was in the context not of determining whether or not there was stalking, but in determining what the appropriate scope of the stalking injunction should be. And in that case, the posts were about a public official.
Yeah.
So a bit different.
I could see the distinction there, but I also
think first we determine stalking. And then
Right.
if the court finds there to be stalking, then the court analyzes what the stalking injunction needs to look like.
Yeah.
And can take into account, constitutional questions at that stage.
Right.
But also, Ms. Ward is not a public official.
Right, Your Honor, I agree with that, but I think the way that I look at this, or the way to think about it, is that I don't think the stalking statute itself makes a distinction between public and non-public officials.
I agree. But I think in the context of determining whether a reasonable person in the petitioner's circumstances would fear for their safety or suffer emotional distress, that's where that would come into play. So, for example, I think it would be not reasonable for someone who's an elected official to suffer emotional distress if someone's complaining about their votes, positions, things like that. That's not reasonable. But if you're just a private citizen and someone starts posting about you.
But that's not what happened here, Your Honor. And I feel like that's actually kind of the story that they were trying to portray.
No, I mean, I agree in terms of the timeline.
Yeah.
But at some point in time, is it your position that regardless of Ms. Awerda's, because she initiated it, Ms. Despain has no obligation ever to stop posting about her?
I don't think she's posting about her. And I think that there's a couple things here. One is that I think the court has to look at this objectively to see if she is directing her communications to...
well, let's give me an example of what she's doing that you think is not posting about her.
I think if she posts about the hearings that have happened and isn't using her name and isn't tagging her and has her blocked on social media, I don't think that those are actually about her. They're about what is happening to my client because of actions that she took and her continuing litigation against my client. I think those are still permitted under the stalking statute. Otherwise, I really do think we step into that First Amendment issue.
Okay. So you're not saying she should be continued, like the examples from early on about, what happened and your not position isn't that should be able to continue forever. Like at some point that could become stalking.
Well, like what's an example of that?
I don't know. Let's look at one of these posts. Like, okay, like May 28th post about that Ms. Despain posted, this is the woman who has terrorized my family online all week and then sent 7 pride flags. He's taken her to her yard without her permission. Blah, 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 blah. Like, can she continue to post that post forever? Or does at some point, and let's say she also includes her name. She includes her name and a photo of her. Like, that's allowed forever?
Well, what was the exhibit number, Your Honor? Can I look at it,
I
please?
just pulled a random one.
Okay.
It's 10, but you can pick a different one. It just seems to me that at some point in time, regardless of who started it, at some point in time, it may rise to stalking. Like, you just can't post about someone forever, even if they started it.
Right. Well, there's a couple things I maybe here. One is I want to go back to the public official part. She was an elected PTA president at the time. It's arguable that is a public official, especially in the context of these schools. Mm-hmm. The second thing is I don't know that they haven't put in evidence showing that she has been continuously posting about her. Mm-hmm. So I feel like we're actually talking about a hypothetical that isn't actually happening. Now, to the extent that they brought up that she has continued to post, it's posting about the hearings. Mm-hmm. It's not tagging her. It's not mentioning. I just went and looked when they said that. It's not mentioning her name, and it's talking about public things that are happening to my client in this lawsuit. Like if they want to bring up some post that they think matches the post that you said and say, okay, this is continued and this is a problem, but these other posts aren't. I'm happy to have that conversation, but that's not what's before the court right now.
Okay.
All right. And I wanted to also say this. So, like I said, my client didn't interact with the petitioner until the petitioner went onto her social media and started interacting with her. And in contrast, there's evidence that my client only commented on one of petitioner's posts. And if you look at petitioner posted twice about my client, and both instances she tagged my client in those posts. And my client only actually commented on one of them, according to the evidence that's in the record. So my client wasn't out there.
Okay, and I get the distinction between commenting and posting. I am as guilty as anyone in terms of interchanging those words, just primarily because I don't comment or post on any social media ever. So I don't really internalize it. But so you're saying that there was lots of engagement in like comment threads on Ms. Despain's social media, but Ms. Awerda posted about Ms. Despain specifically twice, and Ms. Despain only commented on one of those posts.
Yes, Your Honor. Yeah, and then actually the petitioner deleted Ms. Despain's comments on that post. Okay. So, and in terms of the number of comments the petitioner did on my client's social media posts, there were actually, the testimonies, there were hundreds of comments in that time span until the petitioner blocked my client. Mm-hmm. Okay. And so what we ask overall is that the court reject this effort because I think what we saw during the hearing is that my client wasn't randomly posting about petitioner. She didn't go find petitioner and start posting about her. She's posting in response to what's happening to her. And so we're asking that the court reject efforts to turn that into a course of conduct for a stalking injunction, because what that actually does is it makes my client is the victim here of being harassed. And while she didn't file a stalking injunction, because that's not, like she said, she doesn't have the money to hire an attorney. She didn't want to be in this type of litigation. She handled it the way she knew how as a middle-class person, social media. And I think one of the dangers here is if this is turned into a permanent stalking injunction, it could be weaponized against victims in all sorts of cases. So, I know Petitioner's Counsel brought up the idea of a boyfriend and a girlfriend. In that type of situation, maybe the boyfriend's being abusive to the girlfriend, and the girlfriend responds. Let's say she goes and she posts on social media about it. And then he could go get a stalking injunction against her. And I think that's the danger here, is that we don't want to turn the stalking statute into a way to weaponize it for people that are actually doing the harassing. Okay, so one of the things.
The answer there isn't necessarily that they don't get the temporary stalking injunction. The answer there is that maybe they do, but then it comes for a hearing and the court evaluates everything. I mean, we can't stop people from getting stalking injunctions.
Well, I actually, so Your Honor, I'm going to get to this, but I think in this case, actually, the initial request itself was really problematic, and I think that if the full evidence had been presented, that a stalking injunction would not have been entered. I think what happened here is the petitioner filed this verified petition that she signed under penalty of perjury. She claimed that my client was riling up this online mob to go after her. She included those, there were 8 screenshots, like we said. For months and months and months, I think for a year and a half, they represented that those were screenshots on my client's social media. And as was in the testimony, we asked where those came from, and we never got an answer to it because they were not on my client's Instagram post, or Instagram where she only has 200 and some followers, and like she talked about, only her followers can comment. So it wasn't until...
But even if that had been fully disclosed in the petition, and the petition had said, you know, this person is riling up an online mob against me, here's some examples of the mob on various other, you know, pages. I mean, there's a chain there. I mean, it's the Daily Caller article that, you know, references Ms. Despain. I don't think that would have changed anything.
Well, I mean, but that strikes me as problematic in and of itself because they're random third-party posts that had nothing to do with my client. She didn't cause them. She didn't encourage anyone to make them.
Well, I think that's a fact dispute. I mean, Ms. Huerta didn't know that. She didn't know that whether these were people that Ms. Despain had communicated with in some form or fashion, or, I mean, that's...
Yeah.
I think from her perspective, which is, you know, the petition says, tell us why you think you're a victim of stalking, basically.
Yeah.
And so that was her perspective. I mean, I understand you disagree with it, but I don't know that someone, especially given the nature of a stalking injunction, I mean, the time is very quick. You know, I don't think we want people to have to do whole lots of investigation in order and present all sides. That's what the evidentiary hearing is for.
Yeah, but I don't think we're arguing, Your Honor, that they have to present all sides. I think we're arguing that the evidence that's presented itself needs to actually be presented in an honest manner. Those were presented as if my client had something to do with them. She had nothing to do with them. Even the remaining pieces of that request were things that had no connection to my client. There's 2 direct messages that were in there. There's no connection to my client in terms of those direct messages. There were two comments by David Mulholland. There's no connection between my client had nothing to do with him posting what he did. And then on the final page, they actually have, I think, one post by my client, and that post is in the middle. It's like May 26th of 2023, so it's before the pride flags were actually delivered, and it's while the petitioner is continuing to engage with my client. I think she actually posted her 2 posts on social media after that post was done. So I think like that's actually extremely dishonest. There's no basis for stalking there. You're actually the one engaging in this back and forth. Then she put 2 comments by my client after that, and both of the comments are part of broader threads on which petitioner is actually engaging as well. So I think that's what we're arguing, is that it's really problematic. Now the other piece is back to the 8 screenshots. I'm sorry, I think this is the problem, is that it was 8, for a year and a half they represented to the court and to the respondent, and previous counsel, I guess, that these were screenshots that were on my client's social media. They never actually told us where they were from, and petitioner testified that she took the screenshots. She took them and couldn't tell us where they were from. It was my client who actually found them after we got all of the evidence for the evidentiary hearing. And I think that's problematic because it should have been them that disclosed where that evidence was from. And had we not, and so we ended up finding it. Initially, my client found it on that Daily Caller reel, but we weren't able to find all of the comments. And we assumed that the ones we couldn't find had actually just been deleted because they were threats of some sort. It wasn't until after that second evidentiary hearing date that my client found the additional 2 that were actually on a Chad Prather post versus the Daily Caller post. And that's why, because I know they've argued that we shouldn't be able to have the declaration, but I think that would be punishing us for them submitting evidence and not disclosing where the evidence came from. And that seems very unfair. Because had they disclosed where the evidence came from the beginning, as I think they should have, since it was their evidence, they found it, they screenshotted it, we wouldn't have had to go through that whole rigmarole to begin with. Okay, let me see here. The next piece is that I think we're asking that the court find that Ms. Despain did not engage in a course of conduct directed at respondent. And I think, as they've discussed, they have to show by preponderance of the evidence that Ms. Despain intentionally or knowingly engaged in a course of conduct directed at a specific individual. And so here...
How do you get that? I mean, just because might be a course of conduct doesn't mean there's stalking. That's just the first part of the analysis, right? I mean,
Yes, Your Honor.
I guess, and I mean, I see your point, but it seems like even just the engagement in the comments on Facebook, why doesn't that at least be a course of conduct? Again, it might not mean they're stalking. You still have to meet all the other requirements, but it just seems like when people are engaging on social media, you've got a course of conduct. Again, it might not be stalking.
No, I understand what you're saying, because
Yeah.
then you'd have to go to the second step of this. But I actually think, I mean, the first step is there for a reason.
No,
And
I
it's
agree.
and it's to determine whether, I think we do need to look at whether there was a course of conduct. I think here there was not a course of conduct actually directed at petitioner. And
Even though she's responding to petitioner? I mean, she's directing her responses to the petitioner. I understand what you're saying, I just I don't see that limitation in the stalking statute.
I think there is a case, like the Harris versus Hunt case, where the court suggests that you look at kind of objective factors to determine if the person is directing their conduct, comments, or like social media in this case, at an individual.
Right.
And so here, like I said, she never tagged the...
But even just, I mean, there's pages and pages of them on comments.
Yeah.
You know, you're awful. No, you're awful. No, you're the most awful. No, you know what I mean? I mean, pages and pages.
Yeah.
That was clearly directed at her. Again, it might not be stalking.
Yeah, but just to go back, in their argument, I think they're arguing that actually it's conduct after May 28th, 2023 that counts for stalking.
I think
So
the
really,
scope of the course of conduct is maybe a more interesting is the wrong word, but a more difficult question, I think, for me is the scope of the course of conduct rather than whether there was a course of conduct at all.
okay.
But you can disagree, obviously.
I disagree, but I think, again, it's because the legislature did put that standard in there, and I think it behooves the court to then analyze whether there was a course of conduct.
100%.
And I think you're supposed to look at everything that happened. When you do that, what you see is, this is not my client, because I think stalking is getting at, are you like randomly posting about somebody? Especially because here we're only talking about social media. There is no physical correspondent from my client. There was from their client, but not mine. And I think that actually distinguishes a lot of the cases out there. Even with Harris versus Hunt, for example, I know Petitioner's Counsel said that it was only about social media posts, but that's not true. In one of his posts, he talked about how he had been doing bad shit in the town, and so there was a suggestion that he had been in the town near where Harris was, and he had also been at an inn across the street from where Harris worked. So there's a physical component to that. Here there's none. It's only social media posts that are at issue in the case. And I think that actually makes the course of conduct question more difficult, because it is just speech. It is my client just responding to being persistently harassed by the petitioner. And while we agree that conduct started online, it moved into the physical realm, and not because of my client, but because of the petitioner. And then it went into what we consider this to be lawfare. So, and then I wanted to start on this piece about the request for the civil stalking injunction, because one of the arguments that the petitioner makes is that the standard for a stalking, for the imposition or the granting of that temporary stalking injunction is low. And they cite Peterson versus Armstrong for that case. It's a footnote in there. I just wanted to point out that if you look at the footnote, the court cites a decision from the Iowa Supreme Court and then offers the following gerund. Out of necessity, Domestic abuse procedures are routinely instigated upon a pro se petition, and consequently some leeway must be accorded from precision draftsmanship. That's not the case here. This isn't a pro se petition. This was drafted by attorneys, and I think that actually makes it more problematic that there was evidence submitted that they were not able to disclose where that originated from. And I also think, petitioner talked about our adversarial system, and I agree, that's definitely what we have. But when you're going to a court and asking for an ex parte order, that's a very different thing. And so I think the court should actually expect that attorneys comply with Rule 11, and so that's it.
I expect that on at all times, and I think it applies to unrepresented parties as well.
Okay. Well, yeah, but Your Honor, I just think here this was a real issue. Fair point. And but I think what they're actually arguing is that the standard is so low that they can present misleading evidence in order to get that initial temporary stalking injunction. And I think it's problematic because that actually caused damage to my client's reputation. Because as soon as that was entered, there are people posting about it on social media and calling her a stalker. And so that's why we think even that first temporary stalking injunction should be dissolved, and then the case should be dismissed.
And that is the stalking injunction that's in place, the temporary stalking injunction.
Yes, Your Honor, yeah. And I think part of what you see, and just to go back to this Harris versus Hunt case, it's a really interesting case because this guy Harris isn't really doing anything with Hunt. He's not posting about him. He's trying to do his job at this town. In response, Hunt is posting just nasty, vile stuff about him, right? Like he's a wife abuser, he's a child abuser, like all this really disgusting stuff on the Facebook, knowing that number one, Harris can access it, but also knowing that it's done on the town's Facebook page as well, plus the physical pieces of it. But what I thought was interesting is both parties got stalking injunctions in that case against each other. The only person that actually appealed it, though, was Hunt, the guy who was actually doing the harassing. The petitioner never appealed it. And it would have been interesting to see what that appeal looked like, because since he wasn't actually engaging with him, I think an appeal on that would have actually caused that stalking injunction to be dissolved. But I suspect what happened in that type of situation is the person says, well, I'm not engaging with him anyway, so I'm not even going to bother with this. It's not worth my time. But it's unfortunate because now that the victim in that case is really being tagged as a stalker. Okay. Oh, and then I just want to point out in that initial request as well, a big piece of what's missing is petitioner's role in all of this. Really, if you read the request for a civil stalking injunction, it's as if my client just randomly found petitioner and decided to post about her. And that's not what happened at all. And that's my point. Like, this was a very dishonest, I think, and inappropriate request.
And at this point, the court's not reconsidering. The court is not making a determination based on what's within that initial petition. We have 2 days of evidence. That's what the court's considering. So, is the point as to the argument that there were misrepresentations or maybe material non-disclosures in the petition, does that go to the fees question, or does that go to, how is that relevant to the court's decision now, having heard 2 days of evidence?
I think it goes to two things. We actually are asking, and you may not do it, we're asking that initial temporary stalking injunction be dissolved. We do not think it should have been issued in the first place because of the way it was presented.
The determination is made after the evidence. The question before the court is, should a permanent, even though it's not permanent, I think it's 3 years, stalking injunction issue, or should the initial temporary stalking injunction be dissolved? And that decision is based off of the 2 days of evidence, not what's in the petition.
Yeah.
Do you agree with that?
Yeah, I agree with that, Your Honor. Yeah.
Okay.
Our point was just that we just think, based on even what was initially presented, it should be dissolved. I understand what you're saying, though, that we've had all this evidence, so that's what you're actually thinking about. Got it.
Okay.
And then I also think that what happened with that initial petition because this is what our view is. It would have never been issued had this actually been presented the way what happened. I mean, they're very worked up about how my client posted on Give, Send, Go, right? She allegedly misrepresented what the case is about. Their entire request for that initial civil stalking injunction is totally dishonest in a much worse way, because it led to the court, I think the court being misled and entering the stalking injunction. So it would also go, I think, to the attorney's fees question as well. Okay. And then I'll just add, I think this is kind of clear, but the 2 days of the evidentiary, like I initially said, shows even more how dishonest that, or misleading, I know people don't like to say dishonest, but misleading, that initial request for a civil stalking injunction was. Okay. Then on this issue of the course of conduct, I think when you objectively look at this, that it's very clear that my client was not directing her posts, again, posts versus comments, that her posts were not actually directed at the petitioner. And that's kind of a key point, because you're looking to see if the course of conduct was directed at an individual. And so here, like I said, she never tagged the petitioner in her posts. But what's clear is that on the flip side, it was clear the petitioner was monitoring my client's posts. So for example, when she posted about how she had, Ms. Despain posted about how she had received this delivery of 7 pride flags and how it had traumatized her and her family, within 3 minutes, the petitioner reposted that and then said, "Happy Pride Month to our favorite Murray resident." So she was clearly monitoring my client's social media. In addition to that, on May 30th, my client blocked the petitioner on all social media and has never unblocked her. And so if you look at Harris versus Hunt, that court actually suggests that blocking someone on social media is objective evidence that you're not directing your comments to them.
Well, that's not exactly, I didn't really read Harris that way, but I don't know that it matters, but I just didn't read it that way. I mean, because they sum up by saying, you know, paragraph 14, we have no trouble concluding that all of Hunt's Facebook posts were incidents in which Hunt communicated about Harris directly by any action, method, device, or means, and were actions taken using the computer, the internet, or other electronic means. And then they say, and this is true, even if we assume, for purposes of the discussion and without deciding that Hunt had no subjective intent that Harris ever see any of the posts. And that subjective intent, I read that to be tied to, you know, like if you were to block someone, you could argue that you don't have a subjective intent that they see them, but they ultimately concluded that doesn't even matter.
Right. Hold on, I have
Which one?
Sorry, Your Honor.
That's okay.
I have it on there.
It's a lot of cases, a lot of briefing.
It is. Oh, maybe I have it. Oh, I have it.
Oh, that's like when I can't find my phone and I realize I'm holding it.
Okay, yeah, I feel stupid. Let me see here, I have this.
And I was reading paragraph 14.
Yeah, so okay. Just a couple of things. I think the court is correct. They're not considering subjective intent in terms of who he intended to do it, because he actually testified, I didn't intend for him to see it. And so, but in paragraph 7, they say, yet Hunt knew that Harris had looked at his page in February 2022 because Harris had liked a posted photo. Hunt testified that he had since blocked Harris and everybody associated with him from accessing Hunt's Facebook page, but Hunt did not offer any testimony about when he blocked Harris from accessing his page. So I think and the reason I think the court highlights it is that's suggesting that the block would be an objective factor to show that you're not targeting someone. They're not going to look at their subjective intent. I understand that. And so that's why we have to look at objective things that you do on social media to be able to not have that communicate with the other party. Okay. So that's why, yeah. And like I said, I think finding a course of conduct here actually sets a really bad precedent for victims who are trying to get stalking injunctions, because it means that their abusers could actually get stalking injunctions as well. And I don't think that's a good thing. I understand the point that then they could get evidentiary hearings, but I think part of this is when you're in these situations that you don't want to be involved with people, your abuser. Then the second factor, so we asked that the court find that there was no course of conduct. The second factor is the fear, this idea of whether a reasonable person in that person's situation would fear for the person's own safety or the safety of a third individual. There was one issue that they raised, I think in their response to our closing argument, and it was that we waived our objection to her claiming that a reasonable person in her situation would have feared for her safety. That was the thing. And so I just wanted to address that really quickly. First, I think that courts actually pretty regularly combine the two issues together. So let me get.
And the two issues meaning fear for the safety and emotional distress?
Yeah, that's right. And so, because in Schmidt versus Peterson, so this is a Court of Appeals case from January of this year, in terms of the court says, and second, the petitioner was required to show that the respondent knew or should have known that the course of conduct would cause a reasonable person to fear for the person's own safety or suffer other emotional distress. So I think actually it's really one big analysis. There's not two distinct issues. I'll just also add that we actually addressed every single argument that they made in that section in our brief. So, and then the third thing is this. She admitted, petitioner, repeatedly during her testimony that she didn't think that my client's posts about her were threatening. And so I know that's subjective, but I think that actually still goes to an analysis of whether a reasonable person in that situation would feel fear because of my client's posts or even the cumulative effect of them. Okay, and then the other piece is that
and I mean they would say, well, maybe in isolation each one of those posts were not threatening, but all of the posts and comments generated, sort of a frenzy, which included the, death threats, voicemails, online and otherwise. And so that's their response.
I don't think that the statute allows the court to hold my client responsible for third-party actions unless she actually causes them.
I don't necessarily disagree, but what's the definition of the word cause there?
Well, in our brief, cause was she actually needs to make the other person do the thing.
Okay.
And so in this case, we actually submitted evidence of the one example where she did that, and it was with Ms. Solas when she asked her to post or share things, and Ms. Solas did that in response to her. That's an example of causing. But if if what can happen is that
And what about if, Ms. Solis did that, and then one of Ms. Solis's followers reposted, and then one of their followers made a death threat? Where?
I don't mean to laugh. I'm sorry.
No, I think it's a really difficult question.
Yeah, I think at some point we have to cut this off. It's not going to be my client's responsibility how third parties are responding. And I actually think that's actually good. That gets closer to what happened here, maybe, is that there's an article that comes out.
Even though, part of it is, by asking Ms. Solis to repost it, and I think Ms. Bain was pretty clear in her testimony. She wanted this widely publicized.
Mm-hmm.
And if that, so where does the causation chain cut off if that was her goal, to get it widely publicized?
I think then you have to look at the content of the posts themselves and see if there's any indication that those posts are encouraging people to make threats or to contact the petitioner. As petitioner herself testified, they didn't. Otherwise, I think we're getting into an issue where it'll chill free speech, because if I post on social media and I'm responsible for how random third parties respond to it, I'll stop posting, because I don't want to be in a situation where someone thinks, oh, I'm now, responsible for these threats, when I haven't encouraged anyone to do it in my language, and I certainly haven't communicated with any of these people. There's no evidence to communicate with any of these third parties except for Ms. Solas in terms of posting. And I think actually that's what the statute contemplates as well. It contemplates a more direct connection, because I think the way it's worded is it's either you or you're trying to contact the person through a third party. Well, it would be hard to argue that my client was trying to threaten Ms. Awerda through a random third party who commented on the Daily Caller's news article. Does that make sense, Your Honor?
It does.
All right. Okay, sorry, I said that. And I will say it is possible that Ms. Awerda had some sort of fear based on how some third parties responded to the articles. But I think that fear that she felt is more likely because of her own actions. As she herself said, she's never sent anyone 7 pride flags. That was a very offensive thing to do for my client, and I think there's a lot of people that probably find it offensive. I'm not saying that people should do that. We're definitely not saying that. My own client has said people shouldn't make death threats. But you can see that her own actions have likely caused people to respond in ways that she doesn't like. Anyone that is engaged on social media knows that is definitely a possibility. So. And then on the second prong, which is that my client knew or should have known that her course of conduct would cause a reasonable person.
Although now it's new or was reckless as to whether. That's the current statute.
Oh, yeah, thanks, Your Honor. Counterman, you're right. Okay. So this is the individualized objective standard, and courts applying this individualized objective standard have considered such factors as the victim's background, the victim's knowledge of the relationship with the defendant, any history of abuse between the parties, the location of alleged stalking. This is really an opportunity for the court to consider everything and to then understand whether a reasonable person in petitioner's situation, right, would actually feel fear or emotional distress. And here I think the court should actually find that they would not in this case. And a couple of reasons. One is that, as I think was made clear in the evidentiary hearing, petitioner instigated this back and forth. And she did it by, again, ordering those pride flags on May 16th, by emailing Ms. Dunn, by then going onto my client's social media and commenting. My client had no idea who she was. Then constantly escalating this thing. So it goes from back and forth comments, some of them not very nice, that happens. And then on the 26th, I think, she threatens legal action. On the 27th, she threatens legal action again. And that's when she actually says, you make comments about how much money I have to get plastic surgery. Wait until you see how much money I have to get lawyers to go after you. And then on the 28th, we got the pride flags that are delivered to my client's home. And as my client said, and I think you've kind of acknowledged this, but she's home. She sees these random people show up at her house. She doesn't know who they are, why they're there. A very disturbing thing. And it indicates that petitioner gave my client's address to a random third party to have those flags delivered to her home. So I think once that happened, petitioner should have expected some sort of a response. You can't, I think, harass people like that and expect them not to respond in some way. And here, the responses are all social media posts. It's nothing beyond that. And it's not even just social media posts that are randomly about petitioner. They're social media posts, again, versus the comments, posts about things that are happening to my client, how she feels about them. So she posts about, I received these 7 pride flags. This was horrific for me. It was terrorizing. She posts about how she gets the police come and visit her, which I think she should be able to post about. She posts about how she's received a cease and desist letter from the petitioner telling her, even though she hasn't started this, that now the petitioner has decided, we're done. You can't communicate anymore. I get to decide when your free speech ends. You have to stop posting about me. Just notably in that letter, they actually talk about how they're going to sue her for violating the electronic communications harassment statute, not the stalking injunction. And I think, as my client testified, after the police came and they brought that up, she actually looked it up and realized that if she didn't tag the petitioner, she wouldn't be violating the statute. So she continued to be able to post about her and tried to comply with that law. I think that's why they actually switched to the stalking statute instead. And then, like I said, the posts themselves aren't actually directed at the petitioner. And just another thing of note is that there's no evidence in this record, and I don't think it happened, that my petitioner that my client has gone onto petitioner's social media and tried to comment on anything except for that one example. So it's not like she's not trying to interact there, she's not tagging her in her posts, and she's blocked her on social media. So there's really nothing here showing that she's directing it at the petitioner. It's petitioner now who admitted in the hearing that she continues to monitor my client's social media sites. I mean, even today, petitioner's counsel said that she is monitoring my client's social media sites, which, again, shows that they're continuing to stalk her. And I think, again, my client didn't ask for a stalking injunction because I think, the previous attorney made a determination about that. By the time I came on, it was like, well, there's nothing happening currently that would really, I think, justify this. But now that we know that they're actually continuing to monitor social media, I actually think maybe there is a case for a stalking injunction against the petitioner by my client. So, okay. And then I know there are a few other things that they brought up in terms of emotional distress. They said that my client used her full name on social media, but that's actually what Miss Awarda did herself. Her social media says Jennifer Lynn Awarda. So my client didn't tag her, she just put the same name that she's already put out there. In terms of the photo, and then also, petitioner actually used my client's full name in her 2 posts. Again, but those are on her social media, and she used a photo of my client when she posted about her. Then twice. Then the photos are from her social media. And at the time that the respondent's husband got those social media posts, anybody could go onto her social media. So she didn't have an expectation of privacy in the photo itself, or in any of the photos, according to case law on that. And I'll say I wasn't able to find a case in Utah about it, so this is a federal district case out of Georgia, I think. The other point is they keep saying that respondent said that petitioner is a resident of Murray. And I just want to point out, it's a town of 50,000 people. It's not really specific. Also, petitioner herself has said she lives in Murray, that her child goes to Murray schools. She's disclosed that herself. In terms of her association with the Murray School District, the Murray School District disclosed it. They posted the video of her getting the award for being the Volunteer of the Year and for being this incoming PTA president. They also talk about how Mr. Awurda's phone number was posted online, but notably they didn't submit a screenshot showing who submitted it. And that makes it difficult because, again, every single screenshot that they submitted, my client was able to go through and to look at, and then to tell the court, these are not my followers. I don't know who these people are. We could have had the same analysis done for that post. We don't have it because they didn't submit it. And I suspect it's probably because it was a random third party again. Because a petitioner also testified that my client never encouraged anyone to post a phone number, post address, go to her house, call her. So all of those third party things are just random third parties acting the way they want to. Okay, and then just finally on this, again, my client's not posting about petitioner. She's already said she doesn't care about petitioner. She's posting about what petitioner is doing to her and her family. And those actions continue today. We're here today because of what the petitioner did. She chose to take this online dispute that she caused and she instigated and to take it into the legal realm. And really to shut down my client's speech because I think she wasn't winning in that arena. So I think overall, I don't think a reasonable person in petitioner's situation would feel either emotional distress or fear of safety from this. And again, there's nothing in my client's comments that would indicate go to her house, go attack her. In contrast, petitioner sent people to my client's house. That caused fear. Yeah. Now, so we would ask the court to find that a reasonable person in the situation would not feel either emotional distress or fear of safety. Now, again, one more thing on this. If she feels emotional distress, it could be, as she herself admitted, the petitioner, from her own actions and how people responded to those, and the court shouldn't allow her then to use that fear as a basis for a stalking injunction against my client. That strikes me as extremely unfair because, again, there is going to be some blowback when you do the things that petitioner did in this case. And I would expect maybe she feels some emotional distress. I don't think my client should take the brunt and the blame for that. So overall we think this stalking injunction should be dissolved. But if the court is inclined to grant it, I think there's a couple things here. We would ask that you interpret the personal conduct order in line with the Towner decision and the Ragsdale decision, meaning that respondent would be restricted from contacting petitioner, but would still be able to post about her and what she is doing to respondent and her family. Otherwise, I think this gets into the First Amendment issue. And then finally, if the court is inclined to grant the permanent stalking injunction, we do think at that point that the stalking statute should be found to be unconstitutionally overbroad. And in this case, a key point is
regardless of the nature of the scope of the injunction?
Yes, Your Honor.
Okay.
Yes. And the reason is this entire lawsuit is solely about speech. It is distinguishable from Ragsdale, where there was that physical component, right? It's not just he had signs in his yard. He was flipping off the people. He was yelling at them. Harris versus Hunt, where there are still physical components in there. This is just solely about speech. And it's all constitutionally protected speech. There's no allegations here that any of my client's posts fall outside the protection of the First Amendment. And like I said, even petitioner admitted there's nothing in there that's threatening. There's nothing in the post that's threatening. There's nothing in there encouraging people to share their phone number or address. nothing encouraging people to go to their home, nothing encouraging people to call them. They haven't, so my client hasn't actually done anything that would not be First Amendment protected. And so I think at that point, the court should follow the courts in Illinois and DC. And there's two ways the court can handle this. You could either limit the statute, and I think, I just want to be really clear, you'd be limiting it in cases where you're solely dealing with speech, that it would need to fall outside of, that if the stalking injunction is being requested solely based on speech, that the speech would need to be not First Amendment protected in order to be subject to a stalking injunction. Otherwise, this gets into a case where you're impermissibly preventing people from speaking on issues. And the First Amendment is very broad. We may not see the value in people making fun of each other or making comments about each other's looks and stuff like that, but that's not really for, I think, a court to determine. It's for people to just go back and forth until they start getting to true threats or other types of speech that are not protected by the First Amendment.
What if she had just posted this awareness phone number without comment? Is that protected?
I would say no, Your Honor. Yeah,
because that's a threat? Or?
I think you're getting into, like, you're disclosing someone's personal information.
Okay. I don't know. This is why this gets really hard really quickly.
Yeah.
I mean, it's easy to say, oh, what if it just involves speech? Well, I mean, most stalking cases at some level, I mean, they're usually pretty hard.
Yeah,
pretty
Your Honor.
hard to slice and dice.
I think here, though, we didn't have that. There's no examples of my clients posting their phone numbers, their address, encouraging people to do that. The posts are, I mean, frankly, they're pretty innocuous. It's about what the petitioner is doing and how that is impacting her and her family. And like she testified, she wants people to know about this because this happens across the country, that there are people that get involved in these types of issues. So, whether it's pride flags in schools, the trans agenda, gender ideology, and then they end up getting, you can have people target them and attack them. And this is just an example of that. The other thing I wanted to mention is that I think it is important that none of my clients' accounts are monetized. So, there was some suggestion here that, for example, my client posted these GoFundMe posts, and that she was just trying to make money by misconstruing what the case is about. And I don't think that's not what happened at all. She's trying to raise money because she's a middle-class mother of 6 young kids, pretty young, and that this is a huge expense to them. And I think that's something that the court should take into account on that point, is that she's not making money off of this. She's actually, it's causing a lot of pain for her family. Let's see. Oh, okay. And then I know there was discussion about the credibility of the witnesses. And I think here it's very clear that my client is a very credible witness. The two examples that petitioner raised about my client not being credible, one was about the previous attorney's actions. And if you actually look at what happened there, it's after the UPEPA hearing happened, which I don't think went very well for my client, and her attorney didn't do a good job, no offense, but it's after that point that she realized he wasn't doing a good job. So like the two posts that he mentioned about with Nicole Solas, those are before the UPEPA hearing. That's a different situation. After the UPEPA hearing, my client realized, like, oh, this isn't going well. Mm-hmm. The other one was about something that was written in the briefing about when she stopped using the petitioner's name. And I'll just take responsibility for that. If it's a mistake, that should be on the lawyer. If it's in a brief, not on the client. And then what I do think, I do think, though, in terms of credibility, I don't think that Ms. Awarda was very credible here. And specifically, again, I I know I'm kind of harping on this, I feel like, but those 8 screenshots are really problematic. Like I said, she took the screenshots, and then when it spent a year and a half telling us, I mean, not me particularly, but, you know, telling my client and the court that these were on my client's social media site, sending the story that my client had these threats on her site and wasn't even deleting them. I mean, that's kind of what the point was, right? I think that was extremely, that shows that she's not credible. The other thing that didn't strike me as credible is her claim that the first time she learned about my client was on May 16th of 2023, and that when she saw the post about Miss Dunn's death, and her immediate reaction to that was to go and order 7 pride flags to send to her house. That does not that does not seem credible to me. She also testified that she didn't know that my client was LDS, even though she grew up with my client's brother, which she admitted herself. I don't think the testimony that she gave was very credible. Oh, okay. The one other point back, sorry, to the point about the UPEPA hearing. With the declarations, my client was trying to clean up the mess that the other attorney had made. And I know that there were some motions that were filed and that were withdrawn, and even I withdrew some of the motions the previous attorney filed after I took the case, because I didn't think there was a purpose for them. So again, I don't think though that my client it shouldn't be my client's credibility that's questioned. She got a bad attorney. That happens. It's not. I don't think that's a credibility issue on her part. Okay. Sorry, one second. And then a couple other things, Your Honor. You know, on the email that is between Ms. Awerda and Ms. Dunn, my client had to get that through a grandma request. I know Petitioner's Counsel got up here and said that it wasn't within the scope of what was required for the UPEPA hearing. However, I think that actually, that was relevant to the stalking injunction in general. I understand.
Right, but the way to, I mean, the suggestion is that it was hidden, and it sounds to me like what happened is that your predecessor served discovery requests, they objected, and then nothing came of it. And that's not how, I mean, you can't then say, oh, they were wrong to not disclose that. You've got to, if you think the objections were bad, you got to meet and confer and file a statement of discovery issues and see, you know, we can fight about it. So I think that's the point there. Like, I don't.
Okay. I get what you're saying. Yeah, I mean, the process wasn't fully followed.
It would have been different if they said, we don't have anything.
Yeah.
But that's not what they said. They objected as beyond the scope of permitted discovery, and then it was never pursued.
Yeah.
So under those circumstances, I just don't see how they had an obligation to, I mean, I guess they could have elected to produce all that stuff, but they certainly didn't have an obligation to, absent further litigation or something.
Yeah, okay, I get what you're saying on that. They also said that she admitted to sending the pride flags, and I would just say I don't think she should get credit for that here. That happened after my client posted about it and put the video online, and the reality of this is, had my client not been home, that interaction may not have happened, and instead they would have come home to see the 7 pride flags in their yard and had no idea what was going on with this. So I don't think she should get credit for sharing my client's post about receiving the pride flags and then mocking her in that post, because the post was mocking. It was like, Happy Pride Month to our favorite Murray resident. I think that's also kind of a credibility issue. That's not what, she wasn't admitting that she sent the pride flag. She had to at that point. In the video, the volunteers say that she sent them. And then our view is here that my final point. Oh, and then the other piece I wanted to say is this. They also talked about the PTA president piece, how my client did not confirm. If you look at, I think it's 114, Exhibit 114, that is a post where somebody emails the Utah PTA president about petitioner. The Utah PTA president responds and does not say she's not a PTA president. She responds with, oh, we are aware of this. We are concerned about these types of interactions. We're looking into it. And so there was confirmation that she was the PTA president at the time. And as my client also, actually as petitioner also testified, she never disclosed to the public that she was no longer being considered for the PTA president. So all you had publicly was that video where they say, oh, she's the next PTA president, and then nothing correcting that for the record. So I think it was reasonable for my client to think that she's a PTA president. I also think here, using that moniker, there's nothing that bars her from doing that. And I think that's been a big issue that's been brought up by the petitioners. Also, the additional piece that they keep saying is that this was incorrect. This was as if it's defamatory or something like that. And I think if they're worried about information that is not correct, either in a Give, Send, Go post, in a post about the PTA president, then the more appropriate venue or mechanism for that, or vehicle, is a defamation lawsuit, not a stalking injunction. Okay, and then then on the attorney's fees piece, first, in terms of if the court's going to grant a stalking injunction, I don't think here, actually regardless of how it goes on any of this, I don't think there should be, it's our view there should not be any attorney's fees awarded to the petitioner. And I think this goes back to that misleading initial request for a civil stalking injunction. The way that was done, those 8 screenshots, the various evidence submitted with that is really problematic. And I think it actually caused the chain reaction that has brought us here today. Had that not been done the way it was, they would not have had the basis to get a stalking injunction, and I do not think we would be here today. So they shouldn't be able to get rewarded for that by getting attorney's fees. I'll also just note that, as my client has testified, they are a middle-class family. They're already heavily burdened by their own attorney's fees, and they can't afford to pay the petitioner's attorney's fees. And I don't think here there's been any sort of purposeful delay. Maybe there were some...
What about all the motions that were filed and fully briefed and then withdrawn?
I think there was an ineffective counsel issue for that initial piece of it. I don't think that my client should be punished for that, especially when you consider, Your Honor, that, like I said, there was a lot of problems with what they have presented to the court generally. So if there was a delay because the previous attorney was trying to figure out how to respond to it, I think that's part of what happens in litigation. I don't think, and I was saying, I don't think it was purposeful, right? And to the point, I know they were saying my client was dishonest because she said, her attorney filed some things without her permission. That's actually true. And so my client shouldn't be punished because the attorney went and filed motions or things without actually getting her permission before doing it. And I think some of those motions that caused the delay or were fully briefed were just that type of a thing. Okay, I think, will we have a chance to do a rebuttal if they come up, or are we done?
I mean, I want to make sure everyone has a chance to say everything they want. I would like to be able to have lunch at noon.
Okay.
So,
okay.
I feel very like I understand everyone's positions. So.
Okay, thanks, Your Honor.
Thank you, that was helpful. Okay. Mr. Newman.
Thank you, Your Honor. I will. I also was noticing the time and will do my best to be very, very quick. First, I want to quickly hit this, the credibility issue, because I think we can dispose of that very quickly. I think there was some argument that was made. It was, bad lawyering, et cetera. The problem with that, and then an explanation that, hey, most of this stuff predated the UPEPA hearing, but as we pointed out on pages 46 and 47 of our brief, these motions that allegedly were filed without her knowledge include her affidavits or declarations. So dockets 139 and 154, 143, and 140. Those all post-date the UPEPA hearing, and Ms. Despain submitted declarations in support of them, despite now contending that she didn't know about them, anything about them, or what was going on. And I also, I appreciate the contention that, hey, there were things that were filed without our permission, but we've not been told what they were. It's just a general statement, and what we know is we have these motions. There were declarations submitted in support. They've not tried to be withdrawn, and when asked that specific question, she testified that it was because she didn't know what her attorney was doing, which, once again, we submit is not credible. There's been argument about, the fact that it's not fair for Ms. Despain to bear the burden of these fees, but as the court is well aware, clients are bound by the actions of their attorneys. The attorney is the person that they hire. It is their agent who acts on their behalf, and if the attorney isn't doing a good job, they need to be fired sooner rather than later. And I would also submit that the opposite is true. It's especially not fair for the Huertas to have to bear the burden of attorney's fees that were incurred because of the actions of respondent and her counsel. There was a reference to Exhibit 114 in talking about some evidence that supported, apparently Ms. Huerta being the PTA president. I looked at that when it was referenced. It doesn't actually confirm that she's the PTA president. It just says it's an ugly situation. I won't belabor.
I think the suggestion was if she wasn't the PTA president, they would have said she's not the PTA president. What are you talking about?
True, and but I think at the end of the day, I think it's fairly clear, including because the court previously found at the UPEPA hearing, Ms. Huerta never actually became the PTA president. So to continue to harp on that and argue it, I think is not relevant. I understand why they're doing it because they're trying to make Ms. Huerta a public official, but she's not. She's a private individual.
What about the argument on the 8 screenshots?
As it relates to the petition that was submitted?
Or just yes, and also, their contention is that, and this is certainly my recollection, although I could be wrong, that, during the course of the case, it was represented repeatedly that those screenshots were somehow associated with Mrs. Spain, whether they're from her social media directly or somewhere else.
Yeah, absolutely, Your Honor. And initially, I will say, especially during the UPEPA hearing, we believed that they were from a Reels post from Ms. Despain. We subsequently learned that that was not the case.
Why would you have believed that?
Just based on the timing, and I can't disclose attorney-client privilege communications, Your Honor, but it was our understanding based on the images that that's where they came from. It was subsequently learned that that was not the case, and that's precisely why before the hearing we had the meet and confer, and Mr. Maragani and I spoke about it. We agreed to stipulate to it, and that's why we presented that stipulation to clarify that, because once we learned that we were wrong, we wanted the court to know that that was actually the case.
But you can understand their concern, right? Those screenshots are submitted in the petition suggesting, maybe expressly, I don't recall, that they were, and the person who took those screenshots was the petitioner and maybe her husband. That certainly they knew where they came from.
Correct. I do think, however, that the problem is comments were coming in so fast and furious, and they were being done from phones, and they were just snapping them as they go. I think as the court is aware, we submitted just in excess.
Then, they were on the Daily Caller's Instagram page.
They must have been, absolutely. Right. There's no other conclusion is that they were snapped from the Daily Caller's website. But remembering precisely where they were, obviously there was a misunderstanding, and maybe it was a breakdown in communication on my part. Mr. Maragani fell on his sword, and I will do the same, and to the extent it was my misunderstanding, I apologize to the court. Where I do take a little bit of exception is there was really only 2 times that this ever came up. One was in the petition, but I will point out, in the petition, the petitioner is very express. She says that they have emboldened an online mob. Repeatedly refers to it being an online mob, not attributing those specific posts to Ms. Despain, and then they're attached. Obviously, the petition isn't a fulsome pleading like a complaint. It's very short, and so I don't think there's anything in the petition that intentionally misleads or is intended to be misleading as to the source of those documents. It was later at the UPEPA where I represented the court incorrectly that we thought that it came from one of her social media pages. I have now withdrawn that. We've stipulated that that's not where it came from. and do apologize for that concern. But to argue that it was something that continued to be an issue, it's just not true, because after the UPEPA hearing, this case essentially lay dormant while we waited for finalization of the motion for a new hearing, motion for a new trial, the motion that was filed challenging the constitutionality, which all three were subsequently withdrawn, and then the new motion that was filed challenging constitutionality. And so after the UPEPA hearing, it never came up again until the hearing. And so we do disagree that, hey, that we're representing for years that this is what's going on. It was a single representation at a point in time during the UPEPA hearing and nothing else. Very quickly, as it related to the argument, well, hey, Ms. Alwerda must have known that Ms. Despain was a member of the Church of Jesus Christ of Latter-day Saints because she knew her brother in high school. 30 years ago, Your Honor. People change religions. There are numerous Christian sects that agree with or disagree with pride flags. For example, Ms. Despain could have been evangelical Christian. She could have been Catholic. She could have been any of these things. Simply saying that she knew somebody 20 to 30 years ago in high school does not establish that Ms. Alwerda knew the religion of Ms. Despain, particularly given the passage of time, because religions can and do often change. Next, I wanted to hit very quickly the argument that was made about the second element of the stalking injunction statute, and I think it was represented that the subparts, fear for an individual's safety or suffer other emotional distress, are condensed into one piece of analysis. And I would submit, Your Honor, that that's not accurate. That's not how I read the stalking injunction statute, particularly 76-5-106.5 sub 2. It says an actor commits stalking if the actor intentionally or knowingly engages in a course of conduct directed at a specific individual and knows or is reckless as to whether the course of conduct would cause a reasonable person, and then it's broken out into two subparts, to fear for the individual's safety or the safety of a third individual, semicolon, or to suffer other emotional distress. And so even though at times it's analyzed together, they are two entirely separate analyses that can be performed. As discussed during my opening, Your Honor, we think that Ms. Alwerda has established by a preponderance of the evidence under either, and for that reason, the stalking injunction should be kept. That it should not be dissolved. Going to the nature of the stalking injunction and the no contact order, I will say we tend to agree that the guidance in Towner, Harris, and especially the most recent Ragsdale decision provide the best guidance on what that should look like. I think that the standard language that is included in the form complies with that language from Ragsdale too, and so we would submit
I don't
that.
think it does.
Okay, well then, to the extent it would need to be modified slightly to comply with that language, but we would submit that Ragsdale too, that language needs to, that would be the form of the order.
Well, and the part they were concerned about was, which we don't know, the remainder has been stated, there's this pending cert petition, so I don't know what's going to happen with Ragsdale too, but they were concerned about the language about, like, the annoy, don't stalk. That was, I think, what they were concerned about.
And I would say, as it currently stands, under governing law, it's still viable.
No, it's still good law.
It's still good law.
For the moment.
So, and I understand the concern, but it hasn't been overturned yet, and so it's appropriate for the court to mirror that language. Very quickly, the representation that I admitted, or that either I or Jen is monitoring Jen, that's not accurate. We're not monitoring her. We have third parties that will occasionally send us updates and information about what's going on and the new posts that are being made.
Do you disagree with Mr. Maragoni's characterization of these posts that they are, referencing maybe today's hearing? That there's a hearing in the case today?
Some of them are, yes, but others are not. So some are in line with, for example, what we have seen with the others, which are, we would contend are constitute harassment. For example, the mocking of Ms. Alwerda, or in particular the post when she recognized that Ms. Alwerda had blocked her, like, hey, since you've run away and you're a coward, I want all these other people to tell you and let you know, those types of things. There are some that are in that vein as well. There's been argument about the individual posts, that Ms. Alwerda admitted that the individual posts by themselves didn't necessarily cause her fear or emotional distress. While that may be true, really it's the cumulative effect, Your Honor, and I think the court understands that, so I won't beat that up. There was, I believe, some argument that Ms. Despain's reputation was ruined after the stalking injunction was filed, and that there were comments made online about that. Well, Your Honor, the reason it became an issue is because Ms. Despain posted about it online, and she went out, tried to get money representing that this was a case that involved attempting to shut down communications about LGBTQ issues at Murray School District. And then, as we pointed out in our opening brief, followers actually reached out and said, that's not what this case is about. This is a stalking injunction case. You don't need $50,000. And we submitted that as part of our opening there, Your Honor. Let's see. As to the argument about Ms. Despain is not just randomly posting about Ms. Awerta, early on, I think when they were engaged, I think that was true. However, once Ms. Awerta disengaged, that was no longer the case. Because any post at that point about Ms. Awerta had nothing to do with anything that Ms. Awerta was actively saying or engaging with respondent about. And so we would submit that later in time, yes, they became random posts, and that's why they formed the basis of a stalking injunction.
Well, I think their point there wasn't that it was, the posts were not about a random person who was unknown to Ms. Despain. The point was, every comment or post was either in response to the engagement or about the pride flag delivery, so it was not a random person that Ms. Despain picked out of the universe. That's how I took it.
Oh, understood. Just making sure we were clear on that, Your Honor. And then, let's see. Your Honor, while I look through my notes to see if I have any other points, are there any other questions that you had for me?
No.
Okay. I think, the very last question, or the very last one I wanted to hit very briefly was on the issue of course of conduct. Mm-hmm. There was a lot of argument about, hey, well, we weren't targeting Ms. Awerta. I think both Ragsdale 1 and the Harris case disposed of that quite effectively. And in particular, paragraphs 32 and 36 of Ragsdale. Paragraph 32 says, so regardless of whether a petitioner is a respondent's ultimate target, the fact that the respondent engaged in any act prescribed by the statute 2 or more times makes his or her conduct directed at the petitioner. And then paragraph 36, according to the Miller Court, the fact that the defendant did not intend for this message to reach the victim was irrelevant. And here, I would submit that the evidence conclusively establishes that Ms. Awerta was being targeted because her name was included, her image was included, and after there was a brief pause in including her name, Ms. Despain continued to post by calling her the PTA president, which is the invented name. And I think there's been some confusion. We're not concerned by the fact that Ms. Awerta is wrongly being contended to be the PTA president just because she wasn't, but that every time respondent used the term PTA president, it was clear she was referring to Ms. Awerta, and so that was the person she was talking about. And that ultimately is why it matters, is because it shows who her intended target was. Your Honor, I don't have any additional points for you. If there's nothing else, okay.
Thank you. Mr. Margaret, anything you feel like you need to respond on?
Yes, Your Honor. I'm sure you're surprised. Okay, just as an initial matter, I'm sorry, I have like the worst computer in the world.
That's impossible. I'm sure mine's
I don't think mine's a real computer. It's like a Chromebook or something. That's totally cool. Anyway, so not that I'm trying to one-up you. Okay, so first of all, I think one notable thing is Petitioner's Counsel just admitted that if you are a PTA president, you are a public figure. And I think here it's very clear that my client was reasonably believed that she was a PTA president. And then that Exhibit 114 shows that when this email was sent, the response, as you noted, wasn't that that's ridiculous, she's not a PTA president. It was, oh, okay, we're looking into this, we're tracking it. So I think here that goes to the issue of how, if the court's inclined to enter the stalking injunction, how it should consider that personal conduct order. We are talking about someone.
Even though now now we all know that she never was and is not, certainly now, a PTA president. I mean, does that,
I think.
do you know what I'm saying? Like, I understand in terms of maybe the analysis of what was happening at the time, but for purposes of any injunction that we're issuing now, she's not a public figure.
Well, but I would argue, Your Honor, that once you step into
Even though the evidence was she never became PTA president. Yes, it might have been reasonable for Ms. Despain to think that she was, but she wasn't.
right,
I mean,
except.
you either are or are not a public figure, right?
Well, actually, Your Honor, I think you can be a public figure, you can also be a limited interest public figure, and in this case, like, she stepped into kind of a public debate about these transgender issues by going onto my client's social media sites.
So it's then irrelevant whether she was in fact a PTA president. It's just that her engagement rendered her a public figure?
Oh, I see what you're saying. I think it's both, sorry.
Okay.
I think the PTA president piece illuminates this because she did it as a PTA president. The fact that she's not one anymore doesn't change what happened in the past. And my client's ability to be able to post about what has been done and is continuing to be done to her by this person who was a PTA president. I think what they're suggesting is that she should, if she wants to continue to post, she needs to just kind of make random, I guess, like come up with a new moniker for her. And I don't know, maybe
Or
it's
just post about the issue and not reference her?
yeah, except,
At all?
well, I think that would be difficult to do because the issue here and what she's been posting about is about this lawsuit and these hearings.
So when the lawsuit ends, what then? I mean, eventually it's all going to go away one way or the other, right?
Right, Your Honor,
I
yeah.
mean, either the injunction will be dissolved or it'll be put in place and then eventually it will expire.
Right. I don't know what happens after that, Your Honor. I mean, I think if you look at kind of the volume of comments and posts, those have certainly dropped off after petitioner and after they stopped engaging on social media. So I would assume that I can't speak for my client. I doubt that she'll be, she might post about it because, I have to deal with this debt or something like that, but I don't think she's randomly posting about the petitioner generally. Mm-hmm. And even if you look at the different posts, they're usually in response to something that the petitioner has done to her. I received a letter, cease and desist letter. I received a stalking injunction. This is how it's impacting me. I have all of this debt. I need to raise money. These are not random posts anyway. So if that behavior continues, I think you would probably, I think that's what we could expect to see in the future. Okay, and then, I think in terms of the previous attorney's actions, maybe kind of the way to look at this is she fired the attorney. And so it is credible that she wasn't happy with the services and it took her a little while to realize that he wasn't doing a good job. She's not an attorney. So I can understand why it would take some time for that to happen, and I've listened to that UPEPA hearing, and I can understand after hearing that why she probably walked away from that thinking this is not a good attorney. I need to fire him. So I think that's why that took some time to happen. Okay, well, Exhibit 114, I think we've kind of already addressed this. The only thing I wanted to mention, though, is that in her stalking injunction that she filed, I think on June 28th of 2023, she did list her workplace as Hillcrest Junior High, which suggests that she may have still been the PTA president or at least some sort of association with that PTA at that point in time. So I think it's unclear when she stopped exactly being the next PTA president. I know Petitioner's Counsel just brought up this notion of even though she knew her brother, even though Petitioner knew my client's brother, that she may not have known that they were LDS or still LDS. But one of the things he did is he mentioned she could have been some other religion that finds pride flags offensive. And I think that kind of gets to what's going on here. My client was being targeted, you can say regardless of what her religion was, because her religion opposes pride flags. And I think that was kind of an admission about that. That's why Petitioner went after her. It was her religious views, and she actually testified saying this, that her religious views exhibit hatred towards the LGBTQ community. I think that's kind of like the overarching issue in the case here. On the issue of monitoring, petitioner's counsel said that they're not monitoring her, but third parties are. Two things. One, petitioner testified that she does continue to monitor respondent, and that she does it through other accounts that she has and through third parties. That was actually in her testimony to the court. So, and then I think here, even if the third parties are out there monitoring and then sending the information back to them, that's still monitoring. So I would say I think actually they're still monitoring my client's social media. And there's no corollary on my client's part in terms of monitoring what she's doing on her social media. Okay. The nature of the stalking injunction, I think, as I said earlier, like for Towner, Harris, and for the Ragsdale decisions, that actually does require that if a stalking injunction is entered, that the personal conduct order should allow my client to still post about petitioner, but not direct any communications to her, which she hasn't done. That's one of the things they keep saying in that course of conduct, that my client has directed her communications to the petitioner. That's incorrect. As I said, she never tagged her in any of her posts, and she has blocked her since May 30th. These are objective indications that my client is not directing her communications to petitioner. Those objective indications are even supported, though.
What about the post that says, "Oh, she's blocked me. I hope everyone tells her blah, 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 blah." I mean, doesn't that suggest that even if she's blocked, she's wanting the message to get to her?
I think if I was, can I have 1 second here? Yeah. All right, Your Honor, sorry about that.
It's okay.
That post that you're referencing was on May 29th of 2023, so that's the day after that she got the pride flags delivered to her home. I know that petitioner's counsel suggested that she has done other posts like that, but she hasn't. There's no evidence of that. As I said, I've looked at her, the posts that she's done since. There's nothing in there that even says anything like that. I know there was one other post too about, it was like Miss Dunn and Gabriel something to that effect, like, "Oh, go and tell it. Well, why don't you guys go tell it?" But as she testified herself, that was a joke. It wasn't actually, it was facetious. It wasn't meant to be serious. So I don't think here she was trying to target or get any of her communications to Ms. Awarda. And it's actually supported by Ms. Despain's testimony, where she said she doesn't care about Ms. Awarda. She never has cared about Ms. Awarda. What she cares about is what Ms. Awarda has done to her and her family, and her ability to talk about that publicly because of the fact that this happens to other activists like herself. They also talked about the idea of the reputation being damaged by the stalking injunction that my client posted about it. The point is, other people also posted about it. And they posted talking about that she's a stalker. They posted photos of her with, like a sweatshirt on, saying she's a stalker and things like that.
Would they have known about that, but for the fact that she posted about the stalking injunction?
It's a public document, Your Honor. I mean, because I had to go and I had to go through it and look at this because, a lot of what's filed in this case is actually private, so it can't be publicly thing. But that order itself is public.
Right, yeah, and it goes up on the state system.
Yeah, so I mean, anybody could have gotten it.
Maybe.
Petitioner could have sent it to people. I mean, I don't think we have testimony saying that, but
right.
yeah. But I mean, the thing is, it was a public document. It was available to anybody. And I know they testified about the Lee Bryant, who had posted about it, responding to my client and saying this is not, it's a stalking injunction, just keep stalking. Yeah. On that, I just want to note that he's just some random third party. I don't even know who he is, but that's kind of an example of the types of posts that we're talking about here. I mean, that was exposing the stalking injunction, talking about what she did, I would say without any real analysis of what had happened, but. And then they talked about how my client continues to randomly post about Awarda. That's not true. She's posting again about what has happened to her. She's posted about the evidentiary hearing, which is a public hearing, and to expose what happened during the hearing. This is what happened to me. This is how I've been talked about in court, or this is what it was like to testify on the stand. She's not randomly posting about the petitioner. She never has. Everything has been about specific instances, things that have happened to her, and we go through this in detail in our briefing. And then the course of conduct issue again. I think the two, what Petitioner's Counsel cited is about subjective intent. And we agree. Just getting up here and saying, I did not intend my communications to go to the petitioner is not sufficient, because it's an objective standard to determine whether that's what she was doing. Here, I think objectively, because of the lack of tagging of the petitioner in her post, again, not the comments, the posts, and because actually post May 28th, so once petitioner blocks the respondent on social media, there are no more comments going back and forth between them. It's only posts at that point. None of those posts contain a tag of petitioner. After May 30th, petitioner is actually blocked from respondent social media sites. These are objective indications that she had no intention of having her communications be directed at the petitioner. What she was doing, again, is trying to expose what was happening to her to the general public, so they could understand what it's like to be an activist and to be targeted by somebody. And I would say in this case, for your religious views. Okay. Anything else? 1 second, go ahead. Okay, two last points, Your Honor. The first one is just back to that point about not knowing, the petitioner did not know my client's religious views. The first post on May 23rd, I think, 2023, was about her religious views. It was, you're a bad follower of the LDS faith and not a daughter of God. So she did know about my client's religious views. What we're saying is we don't think it's credible for her to say she didn't know about them from the beginning, because she knew my client's brother in high school. And I mean, Utah is pretty heavily LDS. Back then it was even more heavily LDS. I'm sure that they knew each other's religious views. But at least by May 23rd, 2023, she definitely knew them. And then final point is this, but like I said, my client has blocked the petitioner on social media permanently from starting on May 30th of 2023. It's confirmed by petitioner's testimony, where she said that they tried to look up my client on social media and couldn't find her sites. That's what happens when you're blocked. And so she's not trying to direct any of her communications to the petitioner. I don't think, she doesn't care about the petitioner. She said that. She didn't know who the petitioner was until the petitioner went onto respondents' social media sites and started engaging with her, until she went, threatened her with legal action, until she went and got pride flags delivered to my client's home without her permission or knowledge. I mean, this was all, what my client's doing is what she's always done, which is use social media to expose issues and expose people and what's going on in Utah and Murray and in the school district. So with that, we again ask that you dissolve the stalking injunction and grant us attorney's fees. Do you have any questions, Your Honor?
I don't.
Thank you.
I will be lightning fast.
Okay.
Petitioner, Your Honor, I'm sorry, I just feel I'm entitled to the final word.
You are. I was going to get to you.
Thank you, I appreciate it. So first, I think one thing I want to direct the court to is the second day of transcript, page 98, lines 17 through 99, line 15, where during cross-examination, Ms. Despain essentially testified that I will continue to post about petitioner unless or until the court tells me I can't. To that end, Your Honor, You heard arguments saying that the posting, that it continues to go on, has nothing to do, it's not just random, it's all tied to Ms. Awarda. Well, I will tell you, on June 9th of this year at 4:34 p.m. on Facebook, Ms. Despain posted, "Religious freedom is expensive. My latest bill for daring to defend myself against the psychopath that forced the pride on my family. We've now reached $80,000 in debt," and has a copy of the bill. So, as I mentioned, we contend they're of the same vein. Just posting about the ongoing of the case is one thing, but referring to Ms. Awarda as a psychopath and things like that, once again, trying to drum up concerns as it relates to Ms. Awarda and trying to keep interest on the case. There was the argument that Ms. Awarda testified that the LDS religion hated LGBTQ people. That's not the case. She didn't testify that, and I would submit that that's not true. She does not believe that that's what the LDS Church stands for. There was the argument made that I had conceded that being the PTA president was a public figure. I did not concede that, Your Honor. I was simply pointing out that was what they were attempting to do. I think the court understood that. I don't admit that that's a public figure, but it's irrelevant because Ms. Awarda was not the PTA president anyway. The question as to why was Hillcrest listed as her place of work, it's because she was a volunteer there, Your Honor. That's what that video shows. She was a volunteer at Hillcrest, was there routinely volunteering in her son's class, and that's why she listed it as her work address. She wasn't employed there, she wasn't the PTA president, but she volunteered there quite often. And Your Honor, I think those are the final points that I have for you, and we are done just before noon.
Your Honor, can we respond really quickly?
And if he responds, I'm going to respond.
That's the problem. They're the petitioner, so they get the last word. And I really understand, believe me. I really do. So I think we're done. We've got to finish by noon. But thank you for your arguments. I'm hoping, I'm going to take it under advisement, but I've been working on it, and I think I'm hopefully pretty close. So I don't want to make any promises, but I hope that it's not much longer, that at least you don't have to be dealing with me. So, but thank you again for your arguments. It was really very helpful in the briefing and today. I appreciate it very much. So we'll be in recess. Thank you.
Thank you, Your Honor.